Major legislation in the foreclosure field, effective as of 2010, has made significant changes in the foreclosure process that impact greatly upon the ability to foreclose a mortgage and the time frame imposed upon that process. First, a 90-day notice is required for all home loans. One would want to review the statute with care to determine what a home loan is, and it is different from residential property, which is another definition in the statute which creates some considerable confusion. In any event, the 90-day notice of default and the ability to cure is an absolute prerequisite. This presents a concern for lenders because it grafts 90 days onto the process, 90 more days when interest will accrue and create a greater debt. The other side of that is that if a lender is to avoid undue delay, it must send that notice and be geared up to begin a foreclosure perhaps more aggressively than they would otherwise, but they know they have to send the letter, so that is a factor. Something to consider too is that a purchase money mortgage, a true purchase money mortgage, when a lender sells property and takes back the mortgage, is not defined as a mortgage, and the Court of Appeals has said so. Whether a 90-day notice is required for that or not remains untested, but is an unfortunate gray area. The language of the statute would seem to require, too, that if a lender elected to sue on the note, they would still have to send the 90-day notice. Although mindful that a suit on the note has nothing to do with the loss of a borrower's home, there is certainly an incongruity in that. So the legislation is a little fuzzy on at least those 2 points, and there are others. A second aspect of the new statutes of 2010, it was passed in signed in December of 2009, is the requirement to give notice to occupants at the premises of their rights. This means whether you are serving the tenants in the case or not, you have to give them this notice. This creates a couple of problems. One, it's not clear that if someone claims the notice was not given, whether that will be a defense to a foreclosure action or in any way impede that. The other concern is that an occupant is allowed to stay for the term of their lease, written lease, oral lease, or implied lease. This part is revolutionary. What is an implied lease, and what are the terms of an implied lease? That person is allowed to stay under those terms. It should be immediately apparent why this creates issues and problems. It also reverses priorities. Even though a lease is subsequent in time to a mortgage and is therefore junior and subject to extinguishment, there has now been this reversal so that a lease rises to priority over an earlier recorded mortgage, certainly an unusual notion. And it affects the value of a property in foreclosure if the bidder at the sale does not really know what it is inheriting by way of leases, for example, oral and implied. There is then a significant obligation on the lender to maintain residential property from the moment of issuance of a judgment of foreclosure and sale. What that date is unclear because of the language of the statute. But if a judgment is obtained, now the lender must, until the recording of the deed through the foreclosure, and this is an unstated period of time, not as short as the drafters of the statute believed, and open to many, many delays. During that period of time, the lender becomes responsible for maintenance of the property, and that would include supplying utilities to tenants under circumstances that are unclear. So we have a situation of lenders being liable for an expense that can't be measured when a lender does not have a title interest in property. It is merely a lien interest. And by the way, when a property is sold in foreclosure and the title of the owner is divested and the mortgage is gone, there's a question as to whether a lender even has an insurable interest in the property to get the insurance to cover the new liability for torts at the premises, because the lender is liable to take care of the property. Certainly a quagmire. Finally, there is a requirement in home loan cases for a settlement conference in each instance. One would be hard-pressed to argue against the benefits of a conference in a case, and we would not make that suggestion. But the mechanics of the conference are such that it adds many, many months of delay to the foreclosure action, and of course too many of these end in no result at all. It also prohibits lenders from taking any other steps in the case. The conference has to be conducted first, and if there is any delay in that regard, then the foreclosure is delayed even more.